Dear students, warm greetings to you all. Today we will focus the most important part of our Indian Evidence Act 1872, that is dying declaration. This act provides persons who has the first-hand knowledge of the facts of a case but who, for reasons stated in the section 32 of the Indian Evidence Act 1872, such as death or disability, is not able to appear before the court, then his knowledge should be transmitted to the court through some other person. If he recorded his knowledge somewhere, for example on a portrait or register, that record may be produced, or if he told his knowledge to another person, that other person may appear to testify of what he was told. The reason for the exception is obvious. The law wants the best evidence in each case. The best evidence is a document or the personal knowledge of a witness, and if the document has been lost or that witness is unable to appear before the court, then those who have either seen that document or shared that knowledge of the person will be considered as the best evidence. Now we will understand the scope and its applicability. The section 32 of Indian Evidence Act comes into play when the person whose statement is sought to be proved has died or cannot be found or has become incapable of giving evidence, or whose attendance can be procured at an amount of delay or expense which under the circumstances of the case appears to the court to be unreasonable. Next important component of our topic is judicial aspects on dying declaration. If we look at the philosophy of law, which signifies the importance of dying declaration based on the maxim nemo moritus presumptur menre, which means no one at the time of death is presumed to lie and he will not meet his maker with a lie in his mouth. It understands us that though the dying declaration is not recorded in the court in the presence of accused, nor it is put to strict proof of cross examination by the accused, still it is admitted in evidence against the general rule that hearsay evidence is not admissible in evidence. The dying declaration does not even require any corroboration as long as it inspires confidence in the mind of the court and that it is free from any form of tutoring. At the same time, dying declaration has to be judged and appreciated in the light of surrounding circumstances. Recently, our apex court held in Umakant and another versus State of Chhattisgarh, 2014 Criminal Law Journal 4078 Supreme Court. The whole point in giving lot of credence and importance to the piece of dying declaration, deviating from the rule of evidence, is that such declaration is made by the victim when he or she is on the verge of death. It is indicative of the fact that a man who is on a deathbed would not like to falsely implicate an innocent person. Such a statement can be proved when it is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death. The statement will be relevant in every case or proceeding in which the cause of that person's death comes into question. Now the question arises whether oral dying declaration is having evidentiary value before the court of law. It has been determined in the recent case Vijay Pal versus State of Delhi 2015 Criminal Law Journal 2014 Supreme Court held that oral dying declaration made to brother of deceased who immediately rushed to spot that her husband has poured kerosene and set her ablaze is found credible. Dear all, if we question the relevance of probative value of dying declaration, we have answer in recently decided matter by apex court. In Ramakant Mishra versus State of UP 2015 Criminal Law Journal 1947, the Supreme Court held that when a person makes a statement while being aware of the prospect that his death is imminent and proximate, such a statement assumes a probative value which is almost all unassailable, unlike other statements which may have made earlier when death was not lurking around, indicating the cause of his death. That is to say that a person might be quite willing to implicate an innocent person, but would not to do so when death is knocking at his door. That is why a dying declaration to confirm to this unique species should have been made when death was in contemplation of the person making the statement or declaration. We have other interesting thing is admission of surrounding circumstances. In Umakant and another versus State of Chhattisgarh 2014 Criminal Law Journal 4078, the Supreme Court held that dying declaration has to be judged and appreciated in the light of surrounding circumstances. Sometimes the doubt arises in judging the version of declarant. In Prempal versus State of Haryana 2014 Criminal Law Journal 4420, the Supreme Court held that there is no substance in the defense version of suicide theory. Further, evidence of Tahsildar, doctor and other witnesses is cogent and consistent that the deceased was conscious and a fit state of mind to give dying declaration, and the courts rightly based the conviction upon the same. At last, we will see the credibility of dying declaration in contradictory parts. In Pradeep Kumar versus State of Haryana AR 2014 SC 2694, the Supreme Court held that in first part of dying declaration, deceased stating that she caught fire accidentally due to bursting of a stove, but in the later part she stating that she was tutored to say so, but in reality it was her husband who set her ablaze after pouring kerosene on her. The Supreme Court held that second part of a dying declaration inspires confidence and can be relied upon to sustain conviction, since deceased categorically stated that earlier part of the statement was made on the instructions of her husband and later part of dying declaration is corroborated by parents of deceased. With this, I hope all of you understood each and every point clearly regarding the dying declaration as piece of evidence. Next time, we will observe the other interesting principle contained in Indian Evidence Act. Thank you to all.